The Affidavit of Decedent, Successor, and Interest. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this very important form that's utilized in Michigan to withdraw money from financial institutions. This form underwent a significant change as of February 21, 2024. The most significant change affects the amount of money that can be withdrawn from a financial institution or the delivery of an asset from about 25,000 to all the way at 50,000. Huge difference, so that many people can utilize this form without the necessity to involve probate, without the necessity to open a probate file. This form does not get filed with the probate court. There are no filing fees. It allows you to access funds from a financial institution or somebody holding money that belongs to the successor in interest without the necessity of probate. So it's access without probate. Let's work our way through the form. First, let's identify the statute MCL 700.3983 that governs this particular form. And as you can see by the moving cursor at the bottom, this form was revised in April of 24 to go into effect in May of 21. So it applies to dates of death after May 21, 2024. It is PC 598. It is a state court administrative office form, PC 598. Single page, very easy to fill out. Let's work our way through it. The estate of, that's the name of the person that died. The decedent, it requires the first, middle, and last name of the decedent. I typically take the information directly off the death certificate. So for example, if it says John Allen Smith, deceased, that's how I'd write it. If it says John Allen Smith, also known as Bill Ray Smith, I'd include that. I copy the information directly off the death certificate. It identifies in paragraph 1, how are you related to the person that died, the decedent? Are you the spouse? Are you an adult child? What is your relationship to the decedent that authorizes you under the statute to gain access to these funds? Are you the devizee under the will? Meaning, was there a will in which that will named you as the person that takes? Or are you the fiduciary who is an heir of or devizee of the person entitled to the property? So again, paragraph 1 identifies how you are related to the person that died. Paragraph 2 talks about the decedent. This is a statement of residency, the city, state, and county that's reflected on the death certificate. So the domicile of the death certificate is where we take this information from, with the date of death, which says on, and that date section. Now here's a provision of the use of this document. It has to be over 28 days from the date of death. Now this can cause problems, because if you're trying to bury somebody and somebody has just recently died and you want to utilize a process to gain access to financial assets at a bank account to allow for the burial or cremation, this form won't work. You're going to have to use the petition in order of assignment short form probate process to get immediate access. But if it's been over 28 days, this form will work. 3, no real property is included in the decedent's estate, meaning this is not to be used to gain access to real estate like a house, a home, or land, but rather the delivery of an asset that's being held by a financial institution or another person. 4, the value of the decedent's estate, less liens and encumbrances, these are the debts secured by the property, does not exceed $50,000. Now that amount's going to be adjusted annually as a cost of living adjustment. When this document was created, the amount is $50,000. So you could go to, for example, a bank, and there's $42,000 in it, and you're the surviving spouse. You can access this money with this form, no need for probate. 5, there has been no appointment of a personal representative in any jurisdiction, and there are no pending applications or petitions for the appointment of the personal representative, meaning there hasn't yet been any filing for probate in a deceased estate. 6, a petition for assignment has not been filed. This is the petition and order of assignment form that I was referring to earlier, that is a request of the probate court to do a short form probate. 7, I'm entitled to the payment or delivery of the following property. Now there's a line here, and you may not know the amount of money that's in the bank account. You may just know that there's a bank account at a financial institution. So here we would write the account name or the financial institution, for example, Comerica Bank or Bank of America account. We try to use specificity, but sometimes if you're too specific or too narrow, the bank will reject the document. Next, as we move our way through the document, the names and addresses and relationship and share for those people sharing. So for example, if there are 3 children and they're all entitled to a 1/3 interest, you'd include their names or address, their relationship, and their share percentage. If it's just a surviving spouse, maybe you're listing just the spouse name there. But that's the identification. Now you have to be very careful. You can't just simply say that you're entitled to it if the statute prescribes that there's a distribution sharing ratio that's different. You have to state the appropriate distribution pattern as set forth by the statute. 9. The copy of the death certificate is attached. I typically include a certified death certificate, but it doesn't specifically say certified copy, but that's what we use because we're going to present this document to the financial institution with this affidavit and the death certificate. And most financial institutions want a certified death certificate, not simply a copy. Signature, name, address, city, state, zip of the person completing the form. You can see there is no even space for a lawyer to be involved here because this process is presumed that you may act without a lawyer, but you're absolutely welcome to work with a lawyer through this process. There's also a notarization requirement. Again, we strongly urge you don't sign this document until you're in the presence of a notary so that the notary can perform their role. And then if you see the word notice in the bottom, it says a false statement on this affidavit may subject the person to prosecution for perjury. It is critical that you accurately fill out this form and you accurately and honestly fill it out to the best of your information, knowledge, and belief, or you could subject yourself to the penalties of perjury. This form and this process is a really valuable tool to gain access to non-real estate assets from the death of an individual of which you're entitled to payment without the necessity to go through probate. At the Probate Pro, we are passionate about everything probate. In this particular case, the Affidavit of Decedent Successor for delivery of assets is a form and process that you can go through to avoid the necessity of probate. If you have probate-related questions, do not hesitate to reach out to the Probate Pro at 833-PROBATE or visit us at theprobatepro.com.